A federal judge in Arkansas has now permanently blocked a law requiring age verification for social media accounts, deeming it unconstitutional. The judge says that it violates the First Amendment rights of Arkansans because it is a, quote, content-based restriction on speech rights, and the restriction isn't narrowly tailored for a government interest. The Arkansas law would require people under the age of 18 to only access certain sites with parental permission.
Joining us now, our chief legal analyst, Khalif Rhodes. Khalif, I think like a lot of things we're talking about comes down to First Amendment and their content. Content. Two favorite words, I feel like.
I think you guys are listening to some of the stuff that I'm pushing out, which is great. I feel better with you all than some of my students I have had in the past. You know, those 4-hour classes, I'd always say, man, are they getting it? But no, this is speech, and the judge said this. I think this is really telling. He said Arkansas takes a hatchet to adults and minors' protected speech, like the Constitution demands, where it uses a scalpel. Scalpel, why? It needs to be narrowly tailored. You can't be narrowly tailored if you're hitting away with it with a sledgehammer. You need to use a scalpel, and you need to cut through and try to make sure that there's a compelling public interest, and you've narrowly tailored, not wide, to ensure that I can chill someone's speech. And if you're not doing that, it cannot be content specific, and that is the only way you can do it. We have multiple levels of ways that the government can do it. There's this intermediate, and there is this right here, what they're doing. And what I can tell you is the judge told them clear, you guys did not do this right. This is unconstitutional because you're not only infringing on the children's speech by trying to protect them, but you're also infringing on adult speech, which is your unintended secondary effect when you do something like this. Because now if I want to access it, I now have to upload this identification. Similar to the adult entertainment sites where folks are doing the ID bans. States are trying to find ways to limit and stop children from getting access to information that they should not have. However, you have to find a way to do it where you're not infringing on the rights of other folks that do have access to get to it.
Okay, we're both parents, right? We have kids that are on social media. One of the comments out of this court case yesterday, Khalif, it says, parents, not politicians or bureaucrats, should decide what's appropriate for their children. I think we both agree with that. And like you're stating, how do we try to, other than, you know, inside the four walls of your own home, try to sort of help your kids with what they see and how much time they spend on it? How can you legally try to protect them from what they have access to, like you said, without it being unconstitutional and infringing on the rights?
I think the first portion is that it starts in the house, right? And so if you're doing that and you want to limit the access that your child has, then the easiest way to do it where you won't infringe on anyone else's constitutional rights is to start there. And so if it's saying I want to ensure that my kids don't have access to any type of social media apps, and then I'm using that screen time sharing and I'm stopping the access to those apps. Okay, that's the first thing. But now if I'm saying I want to ensure that there's some blanket rule to all minors, yeah, that seems great. But how do I make sure that I'm not also affecting all adults that also want to get access to this? In these situations, I think the Arkansas one was extremely vague in its approach. They had the age limit too high. So what did the governor come back and do? She instantly came out with an amendment to the two laws to try to figure out, well, how can we go around and fix the things that the judge has said they didn't like? So then they lowered the age requirement and they added other social media content to make it sure that it wasn't specifically targeting specific conduct or content, I should say. So those are the ways that you try to figure out, and this, I have to overemphasize it, in an era where we're attacking the judiciary, this is exactly what's supposed to happen. You come out with a bill, someone challenges it, and now you fix the bill. You amend the bill to make sure that it conforms and comports to the constitutional issues that the judge has instructed that are there. You're not saying, I don't like this judge. You're saying, thank you, Your Honor, I'll fix it so now that it can comply. Because what the judge has said is, it can work, but it has to be constitutional. He understands there's a compelling interest, protecting the kids, but the narrowly tailored portion is missing, and you have to have both.
Khalif, this is something that kind of came up yesterday, and Jason, I'm glad you brought up the fact that both of you guys are parents. Sometimes when you bring these cases in front of the judge, it's not that we don't agree with it morally, right? Everybody, I think, would agree that there's things that need to be restricted. But these judges are not basing their rulings on what morally is right. They're basing it off of the law, and that's where it comes down. It's like, I don't disagree with it, but you just have to follow the rules and do it the right way.
I used to teach ethics, and I would tell my students all the time, I'd have them raise their hand, and I'd say, well, who agrees with this? And everyone would raise their hand. And I'd say, well, who thinks this is morally wrong? And they'd all raise their hands. And I would say, well, sometimes, as you mentioned, what we think is morally wrong may be constitutional, and on the other side, things that we think are morally right may be unconstitutional. And so you have to remove your morals, you have to remove your thought process, and you have to go and see what the law actually says. And in situations when we're talking about speech, the government, because this is one of our most protected constitutional protections, you want to ensure that when the government is chilling speech, stopping it, limiting it, telling you that you can't do it, it has to be content neutral. And if it isn't, it has to be a compelling public interest and narrowly tailored. And we've had that happen time and time again with these types of cases. And this is a situation where Arkansas, I like the way they handle it. All right, we'll go back. We'll redraft it. And guess what? Someone will challenge it. And at some point, it's that back and forth where you say, okay, we got it. We finally figured it out and it's not just it landed in front of the right judge. We narrowly tailored it to the point where we're not affecting folks that it wasn't supposed to affect. We're only affecting these folks, and it's specific and it's helping what we're attempting to help. Once you get that balance, then you have one that can't be stopped. And I think they're attempting to do that right.
This is the part of the system, our judicial system, that you like, is when both sides are
working together.
I know it's rare sometimes these days, so it's good to see it happening, at least there in that one state. Khalif, thanks. Appreciate it.